Hello, this is Paul Callahan, the Head of Employment Law at Taylor Wessing. Welcome to our webinar today discussing Uber's defeat in the Supreme Court last week. Just so you know, a bit of housekeeping. We are very happy to answer any questions as we go, and there is a box on which I think should be in the right-hand corner of your screen for you to write any questions, and you should see our speakers' bios on the left-hand side of your screen. So we at Taylor Wessing act for a lot of companies in what is broadly referred to as the gig economy, so companies offering platforms of different varieties and different sectors that allow individuals to take work. So far, none of them have had the status of the people carrying out the work challenged, and generally they've been accepted that the people carrying out work as a result of the platforms to be independent contractors. But the Supreme Court's decision in Uber could potentially change that. It could result in some individuals having now been considered to be misclassified, or it could result in certain companies having to amend or adjust their model to ensure that the people that they serve through their platforms are correctly classified in the way that they would like. Just as a summary in terms of the decision and what it did, it created this overall really important concept that if there is subordination or dependence, then a person is not a genuine independent contractor. As a bit of background, what's really important to know is that in the UK, unlike in most countries, we don't just divide people up between independent contractors and employees. We have a third category, which is a category of worker. And workers do not have employee status, so they do not have unfair dismissal rights, but they do have a number of other rights, which will be discussed by my colleagues later on. And in this case, Uber drivers were found to be workers, so they're not employees. That's important to be aware of, but they are workers, and that does potentially have significant implications. So subordination and dependence, those are really the buzzwords. Documentation is not the starting point. So obviously you want to make sure that your documentation sets out what you consider to be the position, but that isn't what the courts are going to be looking at in the first place. They're going to be looking at the reality on the ground. And now I'm going to hand it over to Shireen, who is a senior professional support lawyer here at Taylor Wessing, and he's analysed the Uber decision very, very closely. Shireen, would you like to talk us through what factors were particularly seen as important by the Supreme Court in this case?
Yeah, thanks, Paul. As Paul said, this notion of subordination / dependence is really important, and the Supreme Court looked at the findings of the Employment Tribunal that pointed towards control and away from self-employment. And the key ones there on the slide are, number one, Uber set the fares and in turn the pay of the drivers. Secondly, the terms and conditions were imposed by Uber, the written terms and conditions. There was no scope for them to be negotiated by the drivers in reality. Thirdly, once drivers logged onto the app, the performance was monitored and their productivity was tightly monitored by the app. And you could say, by definition, that's what often online platforms using apps will do, because they can monitor performance of individuals carrying out tasks, they can monitor customers. So it's inherent in the model that monitoring will often be part of the advantages of that. Fourthly, customer ratings were used as a performance tool. And the judge in the case commented that lots of digital platforms use customer ratings, but often they do so to recommend a product, which is an entirely different scenario to what we had here, which was the customer ratings being used purely as a performance tool for drivers. And fifthly, there was no real freedom for drivers to develop independent relationships with customers. The terms with the drivers made clear that they weren't to have contact with the customers once they dropped them off. They weren't free to obtain or retain the details. The customer details were only supplied during the ride by the app. So in the rounds, that really did paint a picture of tight control by Uber, and it was commented that this was clearly a service which was branded by Uber, and the experience for the customer was an Uber experience. So thinking, sorry, go on, Paul.
No, go ahead, Shireen. That just raises a question that I think is very interesting with the gig economy, that the Supreme Court seems to be suggesting that to be an independent contractor, you have to be a genuine entrepreneur and somebody who can develop your own relationship rather than the one-off interaction that you have via the app. Is that a reasonable interpretation, do you think?
Yeah, and I think a general comment at the end, towards the end of the judgment, was looking back, were these people really free to exercise entrepreneurial skill and to develop themselves? And the answer was no. The only way they could improve their economic situation was to work harder for Uber and abide by its quite stringent performance standards. So absolutely, they didn't look like entrepreneurs, they didn't look independent, and that was the key thing.
Yeah,
so just thinking about the definition of worker, and the decision basically says you've got to go back, and there's no substitute for going back to the language of the statute. You can do what you like in the contractual documentation in one sense, but it's not going to affect this fundamental question, which is, does the person meet the definition of worker under the statute? And it's a very wordy definition. But Section 230 of the Employment Rights Act defines what a worker is, and it says it includes someone who works under a contract of employment, so they are workers, and somebody who is something resembling an employee but is called a worker. So the factors there which go towards the definition of worker is someone working under any other contract. That can be express or implied, it can be oral or in writing, but the individual must undertake to perform personally the work. And this is the mouthful, that work essentially can't connote the relationship of customer-client, or that person can't be in business on their own account. So it sets out, quite clearly all the sort of things you look for when you're deciding whether or not someone is a worker. The other important thing to note about the decision, as well as saying you go back to the language of the statute, it says you have to consider the purpose of the legislation overall, and it's to protect the vulnerabilities of workers. And parties aren't free to contract out of the Employment Rights Act and the definition of worker. So you can say what you like in the written agreement, but you can't get round the fact that it's a tribunal or court's job to scrutinise whether you fit into that category, looking at the statute. Another aspect of the decision, which is really important, concerns sort of working time. When were the drivers actually working? And it was pointed out by Uber that they were free to decide when they worked. They could accept a few jobs, they could accept lots of jobs, so they weren't sort of at the beck and call of Uber all the time. And although the judgment said yes, that's the case, it said very importantly, when they were logged onto the app, they were effectively tightly monitored by Uber. So they didn't really have freedom to choose how they worked and when they worked as soon as they were logged onto the app. That was tightly controlled. And for the purposes of working time, the working time regulations aspect of the case, the decision says that when they were logged onto the app in their territory and willing to, and able to accept rides, they were working for the purposes of working time. And what that means is that Uber will now will be liable to pay people for holiday pay and under the National Minimum Wage Act, pay in respect of that working time. So that finding has big implications financially for working time regulation and national minimum wage purposes.
Shireen, how does that fit with the many drivers who would be multi-apping, so they might be logged on to Uber and to some of Uber's competitors at the same time and just take whichever job comes along? Surely they can't be liable to be paid for that time from 3 different companies, for example, at the same time.
Yeah, you would have thought so, that that isn't sustainable if in fact people were able to log on to various apps and do different jobs. But what the judgment says is that, whilst there was a clause in the written agreement which enabled drivers to do this, there was no evidence put forward that this happened in practice. And it said that, the position might be different if that was the case, that people were working for different apps, but no evidence was put forward to that. And on that basis, Supreme Court agrees with the Court of Appeal that, based on the facts it had in front of it, it considered that people were working when those three criteria were met, and there was no suggestion that people were actually free and able to work for other apps.
Okay, thank you. And so all of that time when drivers have been sitting around waiting for jobs to come in and not actively working, they're now going to potentially be able to claim that they should have been paid at least the national minimum wage. Is that right?
Well, the important thing is that they've got to be logged on to the app. So it's that which would trigger their entitlement.
Okay.
So the significance of worker status it's a gateway right, essentially, the finding that you are a worker, and lots of consequences flow from it, not just that you become entitled to the national minimum wage and holiday pay under working time regulations. Those are the two obvious points, and they were relevant in the Uber case itself. But it also has implications for example, pensions auto-enrolment. Although there is a separate definition in the pensions legislation as to what a worker is, it's very similar to the ERA definition. So I think it would be a brave employer that sort of said, well, no, it's different. Technically, the wording's slightly different, so they're not caught. So I think what that means is employers, including Uber, are going to have to consider whether people meet the criteria earnings-wise for auto-enrolment. And even that is quite an administrative burden, working out whether or not people do meet the criteria, measuring their earnings in their relevant pay period. The other thing that flows is that workers are entitled to Section 1 statements. That's a fairly recent development in the past year, and also itemised pay slips. And that used to be confined to employees, but again, fairly recently that was extended to workers. So you can just see that even in terms of the paperwork and the compliance costs associated with issuing Section 1 statements or itemised pay slips, there's quite a lot in there in terms of compliance costs as well as immediate costs, in terms of any sums that are owed to workers. Workers are also entitled to whistleblowing protection. In fact, one of the claimants in the case was claiming that he was a whistleblower. And finally, another point I think that's worth raising is that this recognition of worker status, it does pave the way for workers to basically apply for collective bargaining recognition, statutory recognition of a union. And that's something that's not going to go away. It will probably just build and build, because unofficially unions are promoting the rights of gig workers and getting more involved in trying to promote their interests informally. Another question that you might have is, what about the tax implications? It's all very well to say that they're workers and we know what their entitlements are under employment law, but what are the implications for tax? Unfortunately, that's a very messy question, because tax status, it only recognises employment and self-employment. It doesn't recognise worker status. So essentially, you've just got a binary test there, and it's not clear where workers would fall. My guess is that they may well be liable to tax as well, tax and national insurance contributions. But I don't really want to say that, because you can't second guess how the taxation would work in particular cases. Any thoughts on that, anyone? Okay, so I'll hand over to Joe.
Thanks, Shireen. So I guess the next question is, well, what is the real world impact for this on Uber? And interestingly, a lot of the newspaper headlines when this Supreme Court judgment was handed down were were along the lines of Uber drivers are workers, and really that is the case. But what Uber have at least started trying to do is to disassociate themselves from agreeing that necessarily all of their drivers are workers for the purposes of employment rights. They have made the point, and that they came out with a statement quite soon after the Supreme Court judgment was handed down, to say that whilst they respected the judgment, that the judgment itself only applied to the drivers who had made this particular claim. This has been going through the court system, the tribunal system, for the last sort of 4 or 5 years. Now, strictly speaking, that's correct. One thing that does ignore is that, as far as we're aware, there are around 1,000 other claims against Uber based on similar facts, which have been stayed pending this outcome. So whilst this initial decision only applies to those drivers who brought the original claim, at the very least, Uber will be expecting a large number of those additional claims now to be able to pass through the tribunals, and assuming that they are on the same facts and the same circumstances, it's likely that they will be found in favour of the drivers. But what about moving forward, and what about the situation with all Uber drivers as things stand? Uber has made no secret that since the initial employment tribunal decision back in 2016, it has been making changes to its terms and conditions, and potentially also it's working, the way that the app works in practice, presumably with a view to distancing themselves from this decision that they should be workers. Now, have they done enough to bring that analysis away from worker status? Well, I mean, if we look back at what the sort of 5 main factors were, which Shireen went through earlier on, for me the key one is this point about setting fares, and that was deliberately the first of the key factors which the Supreme Court mentioned. As far as we're aware, it's certainly still the case that Uber does set the fares, and that the drivers do not have the ability to decide how much a fare should cost. The Supreme Court noted in their decision that drivers do have the ability to reduce the fare, but if they do so, Uber's commission, if you like, stays the same. So all the Uber driver is able to do is agree a reduction in the fare, which is only to their detriment. So realistically, they don't set the fare. Similarly, terms and conditions being imposed by Uber and not being negotiable, as far as we're aware, that is still the case. There's no suggestion that Uber drivers are now able to input into those terms and how they work. And things like the customer ratings are still in place. I believe that Uber have changed how they deal with ratings, and perhaps to remove some of the performance management and warnings that come with that rating system. But sort of looking at it in the round, from our understanding of Uber's business model, it seems unlikely that they've changed it sufficiently to suggest that moving forward drivers should not be workers. And obviously there's the sort of PR and reputational issues of doing that. But having said that, Uber were very clear in their press release soon after the judgment was handed down that whilst they respect the decision, it only applies in their mind to these limited number of drivers. So it's going to be really interesting to see how they move forward with this, and whether they decide to bite the bullet and agree that people are workers, or decide that they're going to try and change their business model further, for example. They've also done things to, I guess, look to soften the blow to a degree. So they brought in certain benefits for drivers, health insurance and accident insurance and that kind of thing. But really that ignores the main issue here, which is, that isn't enough to give people the benefits that they're entitled to if they are deemed workers. So what that isn't going far enough to solve the issue essentially. Now, in terms of a chink of light for Uber, other than the argument that actually they don't believe that the status quo is the same, and they don't believe that drivers should be workers moving forward. As Sheree mentioned earlier, the Supreme Court did suggest that if there's a genuine situation where people are able to use other apps and do in fact do that, it's possible that a different result may be found. So it's possible that they may have some arguments to suggest that that's the case, and I think it may be that they were the victim of not putting forward sufficient evidence that people do actually multi-app, which may have been to their detriment. In terms of these sort of immediate implications for Uber, in terms of any driver who is deemed to be a worker, the main things that they can claim are going to be national minimum wage, to the extent that they weren't receiving that when they were riding for Uber, and arrears of holiday pay, because of course if someone's being treated as an independent contractor, the company has not been allowing them to accrue and take paid holiday. It's possible to claim both of those rights back 2 years in the employment tribunal, or potentially up to 6 years if they bring a claim in the county court. The claim, as we understand it, is just in the employment tribunal. So the stage of the Supreme Court decision is that a new employment tribunal, newly constituted employment tribunal, is going to have to decide how much money essentially Uber owes to each of these drivers who have been successful in their claim for worker status. There's also a potential knock-on effect of national minimum wage compliance and enforcement. So HMRC are responsible for the enforcement of national minimum wage. So in addition to the actual value of any underpayment of national minimum wage, it's possible that, and some people think fairly likely, that HMRC are going to, now that they've got the judgment, look to carry out an audit of Uber and look to carry out enforcement action on Uber, which can result in significant fines on top of the actual payment of the minimum wage.
Yeah, and it's fines of up to £20,000 per worker, so it can be very hefty fines if HMRC step in.
Yeah, and of course they won't necessarily just look to be enforcing in relation to the national minimum wage for these 20 or so drivers who have brought this claim. They would look at it in the round, so that potentially they would be looking at fines in respect of every one of the workers who's been potentially underpaid.
Absolutely, and that is what generally happens in national minimum wage audits by HMRC, separate from this case. They go in and they look at all workers or employees, because they're obviously entitled to national minimum wage too, and then make a fine in relation to large swathes of the workforce potentially, and make fines accordingly.
Yeah, thanks, Paul. And then in terms of sort of forward-looking costs, obviously they need to decide what they're going to do. So there's going to be significant costs of compliance moving forward, whether they do decide to reclassify everyone as workers or not. There's going to be a significant contingency needed to be built in for any risk of future claims, and obviously the cost of starting to pay people minimum wage and holiday pay, and there's going to obviously need to be a very significant audit of their current working practices, because they don't necessarily know to what extent people are earning less than minimum wage. It's possible that some people are earning more, but a very significant audit would have to take place across the business to determine the likely cost, and then putting in place the infrastructure to change the business model, to put in place those things that are required in terms of minimum wage and paid holiday. So they have essentially two main options. Do they buy the bullet, accept that all of their drivers are in fact workers, and make adjustments to the business model accordingly, in which case most likely the knock-on effect of that is going to be added costs to people using Uber's platform, so most likely higher costs of taxi rides with Uber. Or they may think, well, there are further changes we can make to this business model to try and move it outside of the Supreme Court's analysis of status. As I mentioned before, I think one of the biggest headaches they're going to have there is going to be putting in place a scenario where the drivers decide how much each fare should cost. Although it's not necessarily impossible for them to do that. Have a business model where the drivers do actually set the fares. It will just take a lot of, obviously, effort and infrastructure to do that. So I guess the big question is, well, is this the end of the line? Has this clarified everything? Is it now really easy to assess whether someone is a limited company or a worker? And unfortunately, the answer is no. There have always been ambiguities in terms of how to analyse employment status, and that's something which is consistent sort of internationally as well as in the UK, and that's exactly why this case has found its way all the way up to the Supreme Court. What the Supreme Court decision doesn't do is give an absolutely definitive test of when someone is going to be a worker. I mean, in my view, the negative of the Supreme Court's decision is that they were quite focused on particularly those 5 criteria that we mentioned earlier, and basically said, well, these 5 things are met, therefore they are workers, end of story, rather than necessarily going into more detail about, well, which are more important than others. For example, what if a gig economy business has 3 out of the 5, but not all 5? Will they be a worker then? Are there other criteria to be aware of? And I think it's absolutely the case that those 5 criteria that were focused on by the Supreme Court are not the only ones that need to be considered. So it doesn't give a definitive test either way. It gives some idea as to what the courts will focus on as being some of the key elements here, which is helpful, but it doesn't give a definitive answer. It certainly makes very clear that the definition that you're looking at is got to be a statutory question, and clarifies and reiterates the fact, as set out in previous case law, that a court will look beyond the written documentation, and whilst it makes sense to have those documents in place and to be clearly drafted and to set out a position as the company sees it, it's certainly not the be-all and end-all, and it's not even the starting point. Courts are very happy to completely disregard what the contracts say if the reality of the situation is different to what they do say. And so this concept of whether an individual is truly independent, or, as Paul mentioned right at the beginning, is there a level of dependence on the platform in order for this person to earn a living? And that's going to be, a key starting point in any analysis.
I was just going to jump in there, Joe, and say something about the confusing nature of the fact that we've got so much case law, and a lot of it all the way to the Supreme Court, like Auto Cleanse and Pimlico Plumbers was another one. And number one, I think it just reflects the fact that employers often take this all the way because their business model stands or falls on the basis of that classification. So they kind of need to take it as far as they can, because unless they are forced to change something, maybe they don't want to. But the other thing is, it's trying to work out where does it end up. Are we still with a sort of multi-factor approach of looking at subordination, control, mutuality of obligation, all those other things, or has this this Uber decision replaced that multi-factor approach with an overarching sort of test of subordination dependency. And in fact, we had a question about that, effectively asking about the relationship between the multi-factor approach and this subordination test. And I just wanted to say that I think, in a way, the multi-factor test is still there and valid, because after all, that is the factual inquiry that you're always going to have to do, which is reflected in those factors. However, when it comes to worker status, this overarching concept of standing back and looking at everything and saying, in the round, is there a relationship of subordination and dependency, is a new emphasis, and that's a new thing. So you've kind of got to do both, but I think this decision emphasises you are not going to get by a sort of tariff approach, a mechanical exercise of saying, right, well, I've ticked that and that, so I've got 8 out of 10 of the factors. It's much more a holistic feel. That's what comes across in the judgment anyway.
Yeah. No, I completely agree. And the question that was asked referenced the Deliveroo case, where the individual Deliveroo riders were found to be self-employed because they had a right of substitution, so they could bring in someone else. And the question's asking, will that still stand? And I think the point is, you still need a right of substitution to be genuinely self-employed, but it's not good enough in itself anymore. And I think the Deliveroo decision has been appealed, and I would expect Deliveroo to lose now, at least based on the way their model was operating, because as you say, Shireen, subordination and dependency now is the overall test, irrespective of whether you can substitute or not. But if you couldn't substitute, then you'd definitely lose on a case trying to argue that someone was an independent contractor. But it's just not enough now. Sorry, Joe, back to you.
Yeah.
No, I agree with that. It's sort of overall test, as you say, for dependency, but you are going to need to dig into this sort of multifactorial test of those various different things. It's just that the Supreme Court in this case focused in on those 5 points. They didn't really talk about substitution at all, I don't think, in the judgment, presumably because they thought they didn't need to, because there was enough evidence of dependency based on those 5 criteria that they did talk about. So in terms of the direction of travel, where are things headed? And obviously the Supreme Court judgment in Uber has been the thing that employment lawyers and people across the gig economy have been holding their breath for over a year. It's a really interesting time for the consideration of employment rights and the gig economy generally, both in the UK and sort of internationally. In the UK, a couple of years ago now, the government arranged for the Taylor Review to be produced into, which is basically an analysis of modern working practices, and Matthew Taylor put forward a number of recommendations that he thought were appropriate in terms of potential reforms of UK employment law. One of the things that he referred to was this concept of worker, and a recommendation actually that consideration was given to rebranding that, if you like, as a dependent contractor. So you would have an independent contractor, a worker, an independent contractor, an employee, and then in the middle, a dependent contractor, which in a way you can see that the sort of Uber driver model would fit quite well into that. We've been expecting an employment bill from the government for quite a while now, and presumably largely due to coronavirus and having more important things to deal with, I guess, in their view. We haven't had it yet, but we understand that the latest on that is that we're expecting the employment bill by the end of the year. We don't have any guarantees that it's definitely going to deal with employment status and the recommendations that Matthew Taylor put forward. But if they are going to do it, and if they are, for example, going to look to codify the sort of employment status tests more clearly in legislation, then it's likely to come with that employment bill. So we'll wait to see what's in that towards the end of the year. In terms of internationally, it's quite interesting time. The Supreme Court decision, because it came just a few days after Uber had submitted its own white paper to the European Commission, and the European Commission this week, in fact, has been in the process of consultation about what changes should be made to the employment rights of gig workers across the European Union. Now, of course, nowadays the UK doesn't necessarily need to concern itself immediately with any changes that are made there, but obviously that will potentially have an impact on how we see things moving forward as well. Uber, in their white paper, understandably, but based on Uber's approach so far, we're basically pushing to say, you know, our drivers should definitely not be employees as it would be in most other countries. But what Uber do acknowledge is that gig economy, people working in the gig economy should have minimum protections, for example, around health insurance, potentially around minimum wage. And obviously there's been changes to, there's been some quite interesting development in California recently at the back end of last year, where essentially it was agreed that Uber's drivers are not employees in California, but that Uber and other gig economy businesses have agreed on that basis that they should be entitled to a certain minimum level of rights such as minimum wage and health insurance. So it's interesting to see how things are developing across the world, and in a way you get.
And I think with the sorry, just to rudely interrupt you again. What I think is also very important for people to understand is that in the EU, where they do have this binary test, you're either an employee or an independent contractor, the employment laws are generally extremely onerous, certainly compared with the UK, which has a huge amount of flexibility when it comes to employment law, relatively speaking, even though a lot less than is seen in the US and in Canada. So France, Germany, the Netherlands. In the Netherlands, if you're an employee, your employment cannot be terminated unless a company actually goes to court and gets a right to terminate your employment. And it will not get that right unless it follows the very strict rules of Dutch employment law. It's equally difficult in Germany to terminate the employment of someone. And France, of course, is internationally renowned for its onerous employment laws. So within that context, the debate at EU level and the implications for gig economy companies within the EU is absolutely enormous and more significant than the UK in that respect. So, sorry, back to you, Joe.
Yeah, that's great. Thanks, Paul. So, yeah, and as Paul says, other than in the UK, there is generally only two statuses. You're either independent contractor or you're an employee. But with the changes in California and with perhaps some suggestions to the European Commission consultation, it looks perhaps like there is a move towards acknowledging this sort of middle category of a worker or a dependent contractor who isn't genuinely self-employed but isn't fully dependent and therefore an employee of the company. So it'd be really interesting to see how that develops internationally. And you would expect that they will have an eye on the Uber decision and the criteria and factors which were taken into account when looking to change or review their own laws internationally. And I guess just from a less legal point of view perspective, the decision in the Supreme Court is obviously going to promote visibility of worker rights generally. It's a very newsworthy decision. It's not often that an employment case like this gets so much coverage in the press. So it's certainly going to increase visibility and make people sort of aware that there are issues around employment status and worker rights. And the potential knock-on effect of that is the potential for more claims, the potential for people to be aware that there are causes of action that they can potentially pursue. So we would expect the likelihood of further litigation across the gig economy. And of course, it's important to mention that this doesn't just apply to the gig economy. The decision related to Uber, and it's quite sort of fact-specific around Uber's business model. But the test that they went through in this concept of dependency is not just relevant in the gig economy, it's relevant to any business in the UK that engages contractors. So it won't just be gig economy companies looking at this carefully, it will be anyone who engages contractors to assess whether they are genuinely self-employed or should be workers, for example. And as Shireen touched on earlier, that we expect a sort of push from the unions to move towards potentially bringing claims on behalf of their members. There's already a question as to whether genuinely independent contractors can or can't collectively bargain, and that was the Deliveroo case that was mentioned earlier, where it was determined that they couldn't because they were genuinely self-employed and contractors. But there's several fairly new unions who are focused purely on sort of gig economy workers or people who are working in non-standard roles, for example. So we expect a push from them in the future. So that's all we had to say for now, and we can move on to some questions in a minute. Before we do that, we just thought we'd do a little poll to see where people are up to so far. So anyone who's listening who is an employer already or is involved in engaging contractors, just be interesting to know whether what you're planning to do as a result of the Uber decision. So either you'll do nothing because there's nothing to do, you may not engage any contractors, or you feel that you're comfortable. Are you planning to review your arrangements following the decision, or are you going to wait and see before deciding? So just pick which one best represents where you are, and we'll move on to the answer in a second. I guess while we're waiting for that, we could go through, have a quick look at the questions that are popping up in the question box. We've got a question about are there any other gig economies other than Uber that have indicated they're intending to change their model to a worker model, or do you expect to see them rework their practices taking into account the 5 factors? I mean, yeah, that's absolutely going to be the key question. I think the first stage is they're all going to have to review their business model very carefully and decide where they fall, which side of the line they fall. We have seen, I think it's Just Eat who have announced that. I think they announced this before the Supreme Court decision, that they were going to take on people as workers and give them workers' rights. I guess that may have been to sort of preempt the Supreme Court decision and perhaps give them a bit of an edge from a corporate social responsibility point of view, to say, look, we're different to the rest and we do give people workers' rights. So we are seeing a bit of a move towards that. Perhaps if it's a new entry into the market, or people who are sort of reacting, before the Supreme Court judgment. But generally speaking, I think companies aren't yet at the stage where they've necessarily decided one way or the other. They're sort of carrying out their analysis and working out what they're going to do. And I think there will be a mix. I think certain businesses, they just won't be able to, change significantly to move themselves out of this worker status analysis as set down by the Supreme Court. If, for example, there's absolutely no way that the business can allow their users to set the price, for example, they may decide, well, it's just not going to work. But there will be other businesses who think they fall close enough to the line that they can adjust their business working practices and see themselves fall the other side of the line. So we'll have to wait and see how that progresses.